So a warm welcome to everyone. I'm Anne van Aken, Professor of Law and Economics, Legal Theory, European and Public International Law at the University of Hamburg and Director of the Institute of Law and Economics. I'm presenting here the IG of ASIL as a Vice Chair. A really warm welcome to wherever you are, and I'm delighted to be moderating this first session of the Joint Speaker Series. Today's event and the series as a whole is the result of a collaboration between the American Society of International Law Interest Group on International Law and Social Science, in short ILAS, and the European Societies of International Laws Group on Social Science and International Law. And not only am I delighted that there are joint events between EASL, of whom I used to be vice president, and I followed the founding of that IG very closely, and ASIL, bridging the transatlantic gap, but I'm also most delighted that we turn to social science and international law, putting international law on a more solid evidence base. Before I turn to the speakers, a few words on the IG, since this is our first session. So for the European Society of International Law, the conveners are Susanna Godzimirska, Moshe Hirsch, Tommaso Suave, Eske Yildiz, and Eva van der Zee. You can't see them online, but they're here. And that IG was founded about 4 years ago. So last semester, the IG initiated a how-to series with the EASL Early Career Network, and they hosted an event on publishing interdisciplinary books uploaded on the IG's website. This semester, it organizes another session for publishing interdisciplinary journal articles, sometimes in May, also planned to be online available. In addition, the IG is currently working a draft call for the pre-conference workshop at the EASL's annual conference in Vilnius, Lithuania, on the 5th and 6th September of this year. So take note and submit. For those who aren't aware, the ELAS group within the American Society is quite new, having been inaugurated last April at the ASIL annual meeting, and this speaker series is one of our first fruits of our labors. So for the American Society IG, so ELAS, the chairs are Karen Alter and Mark Pollock, who, by the way, has been the brain and organizer behind the scenes for the speaker series. Thanks so much, Mark. And Katarina Linos and myself as vice chairs. So again, here are some few announcements. On September 27, 28, we plan an inaugural ELAS Work in Progress workshop to be held in Chicago at Northwestern University's Pritzker School of Law. The call will be out soon, and we are discussing the ELAS prizes to be given out. So again, do not miss to submit a paper. We are also in the process of recruiting an advisory board. We also will have a business meeting at the ASIL annual meeting in Washington, the exact date to be determined, with an informal roundtable on publication strategies for interdisciplinary work, followed by drinks in the evening. So if you are planning to be at ASIL, please join us for that. So in the name of the organizers of this event, let me warmly invite you to follow the activities and join them, and just write an email to any of us. But now, finally, to our today's event. Let me introduce the speakers. You have seen the title of the work, Rewriting Precedent, How International Courts Shape Compliance, which is a joint work of Sergio Puig, Jeffrey Kucik, and Lauren Peritz. Krzysztof Pelc will discuss the paper. So we are fortunate to have not only Sergio, but also Jeff with us, and of course, Krzysztof. All of their CVs are incredibly impressive, and thus it would take too long. So I would say only a few words, leaving out the details and all the prizes they won. Let me start with Sergio. Sergio has the chair in international economic law at EUI, which is a joint chair between the law department and the Robert Schuman Center, which is an interdisciplinary center since last year. Before that, he was Evo de Contini Professor of Law at the University of Arizona. He's the co-editor-in-chief of the Journal of International Economic Law and an AGIL board member. Sergio is also the co-founder and current vice president of Trade Lab Org, an organization to facilitate assistance in international trade and investment matters by law school clinics. Jeff Kucik is associate professor at the School of Government and Public Policy at the University of Arizona. He previously worked at City College of New York for 3 years, where he served as the director of Masters in International Affairs program. Prior to that, he was a postdoctoral fellow at Princeton University. And Sergio was also at Princeton, but no, Stanford, right? I took this out. It's too long by now. And he's primarily interested in the politics of international law and organizations. For example, he would look at why countries enter into formal agreements and how those agreements shape member state behavior. And I'm saying all this because when you read the paper, that all this comes into the paper and informs the questions of the paper. Krzysztof Pelc serves since 2023, sorry for the disturbance of my dogs in the background, as the Pearson Professor of International Relations at Oxford University. Before that, he was William Dawson Professor at the Department of Political Science at McGill University, and his research examines the international political economy with a particular focus on how the design of rules can affect the odds of cooperation between states and how some rules benefit some countries over others. And again, we couldn't find a better commentator on that paper. Sergio and Jeff will present around 10 to 15 minutes to present the key points from the paper, and then Krzysztof will give a 5 to 10 minutes comments, and so we should have around 25 minutes for discussion. This session will be recorded, and a few hours after the event should be on the ASIL website and on YouTube. Unfortunately, it was only possible to organize this as a webinar and not as a Zoom meeting so that we can see everyone's faces. But please do feel very encouraged to put your questions in the Q&A, not in the chat, in the Q&A, which we will monitor. And so we would be most happy to take your questions in the discussion. And with this, I give you, Sergio or Jeff, whoever wants to start the floor. We very much look forward to your presentation and the comment later by Krzysztof. Thank you.
Well, thank you so much, Anne, for that wonderful presentation, and for this initiative, to you, to Mark, to Karen and Katrina, and as well to Krzysztof for his willingness to comment on this paper, which is, as you said, is a co-author paper with Jeff, who will present the second half of the paper, and Lauren Peritz, who is a political scientist based in UC Davis. And this is the first of 3 papers where we are trying to evaluate the political behavior of international courts. And for some context, as many of you know, there have been accusations of legal overreach against many international courts, including the appellate body. And in the context of international trade law, the common assertion is that the WTO's appellate body, by heavily relying on precedent, was the victim of its own success, right? That it was too rigid in its application. So we want to evaluate these and other claims by looking at the precedent. But our overarching aspect of the project is to understand how international legal rulings affect state behavior, and at the same time, how this state behavior affects the application of precedent, and more generally, how the content of decisions impact how they matter. Our approach in this paper is to try to leverage 2 different sets of data sets, right? On the one hand, a very impressive data set put together by Lauren, where she has been collecting information about the conformity with decisions issued by the World Trade Organization's appellate body, right? And on the other hand, we use a different data set to try to understand how precedent has been applied by the appellate body, which is one of the only international tribunals that applies its own precedent routinely. This data set contains more than 5,500 applications in more than 100 cases. And of course, we include some legal analysis. But let me tell you a little bit about the data set. So, for example, this is the data set that we use for analyzing precedent. And what is important in our analysis is that we have coded every single application of precedent in four possible categories, either following, extending, narrowing, and distinguishing precedent. Most of the applications of precedent, as it turned out, are applications of following precedent. But there is like a 15% of applications, right? Just that 800 applications that are either narrow or distinguish the prior application. And in this paper, we're interested in that, in part because we have seen, thanks to our other data set, that there has been a decline in the compliance with decisions, and that has been rather erratic by many countries that have been more reluctant to comply, especially after 2009. So this is a small summary of the compliance with the cases as per the data set of Peritz. Now, in prior papers, using that data set, we have concluded two findings, right? That first of all, that states are less likely to comply when adjudicators extend precedent. In other words, when the appellate body extends the prior precedent to new situations. In those cases, likelihood of compliance falls by half. Then we also analyze what happens after that. And we have found that adjudicators adapt precedent rather than following it when previous rulings resulted in non-compliance. The appellate body is twice as likely to adapt its own precedent in the wake of non-compliance. What we're interested in this paper is what happens next. Whether by adapting the precedent, now states are more willing to comply with the decision. In other words, our argument is that adaptation, in other words, the change of the application of precedent, is an effort of the appellate body to reduce the compliance cost. A very quick example, right? By narrowing a ruling that be applying as such, as we know it in the WTO law, right? Apply to bring down a particular legislation to as applied, right? In this instance was applied incorrectly, that might be more palatable for the respondent. And respondent states, which are facing the same legal battles as before within their own constituencies, they're more willing to comply because this is lowering their cost, correcting the ruling perhaps, and they will perceive it as less overreach. So with that, I pass the word to my colleague, Jeff Kucik.
Thank you, Sergio, and thanks everyone for tuning in today. So based on what Sergio just identified there, our kind of core interest is, if the appellate body is trying to respond to prior non-compliance, as one of our other papers shows, then does the appellate body's kind of effort here to kind of strategically pick and choose its moments to adapt precedent, does that effort by the AB actually induce future compliance? And so to test that, we use a mixed methods approach here, where we present some kind of very big picture, kind of preliminary large N evidence, where we do find a strong correlation between precedent adaptation contingent on past non-compliance and a change in behavior. So what makes the WTO so interesting, not just substantively, is that it's a really interesting kind of social science laboratory for looking at how these cases are related to one another, because we know the same legal issues come up all the time among the same member countries over and over again. So we have kind of this natural sort of laboratory here where we can see that legal issues come up over and over again. They're continuations of arguments that have been had in the past. And so the AB has an opportunity to gradually adapt case law over time. And that allows us to leverage those actions for looking at changes in state behavior. So our large N evidence is an attempt to do that. But what our statistics can't do is really get at the detailed kind of politics around specific readings of the law. So what we did in addition to the large N analysis is we did a series of case studies where we tried to find what we kind of affectionately refer to as family trees of disputes, where we can trace particular legal issues that are coming up over and over again in repeated disputes over the history of the WTO's dispute mechanism. And one obvious example of that is anti-dumping, right? So anti-dumping is one of the most frequently disputed areas of WTO law. And the US in particular has been on the respondent side of anti-dumping disputes frequently, as we know, to the extent that about 10% of all WTO disputes in total are just the United States being sued over its anti-dumping practices. So this is a very clear example of an issue that comes up repeatedly, and it allows us to look at, here we are once again, the WTO is a member has brought a case against the United States. The US is standing there defending its practices. How is the appellate body interpreting the law over time, interpreting the obligations? Is it changing its strategy? Is it continuing to hammer the same legal nail over and over again? And how does this all matter for state behavior? So one example of what we looked at here is, or one of our kind of family trees is fourth remedy disputes. So this is a selection or an excerpt from a table in the paper that you can look at in more detail. I won't read this all to you now. But what we did here is we looked at, in one of our kind of sets of case studies, 3 fourth remedies disputes where there's a clear lineage. One decision gets made, a future case makes specific reference to that prior decision, and that means the AB has a choice to make. Does it stick to its previous reading of the law? Does it adapt the law? Does it extend precedent? What is the AB going to do, and how is that going to matter for compliance? So as many of you know, fourth remedies cases involve an important legal issue, which is that the anti-dumping agreements say that members may respond to dumping with one of 3 possible policy instruments. So that's a price undertaking, an anti-dumping duty, or a provisional measure. But the United States has argued that, in a sense here, silence is permission, that the anti-dumping agreement says, yes, you can do these 3 things, but it doesn't say, no, you cannot do other things as well. So what's happened is that the US has been sued repeatedly over what its trade partners accuse of being or allege are fourth remedies, right? The US using policy instruments to defend its economic interests that are not enumerated in the anti-dumping agreement. So we have 3 examples of that in our case study. The 1916 Act, which actually authorizes criminal proceedings against foreign firms alleged to have dumped in the US market, as well as charging treble damages against those firms. The Offset Act, which was a policy by which the US redistributed anti-dumpings to injured domestic industries. So trade partners alleged that this was a subsidy and therefore a fourth remedy. And then more recently, the enhanced bond requirement that required foreign exporters to pay a duty upfront, essentially putting a velvet rope, so to speak, or a cover charge around the US economy before they could do business with America. So all of these things are fourth remedies in the view of America's trade partners, and they precipitated a long series of disputes. So what we did is we looked closely at the AB's ruling and how it read the law. And there's a lot more detail about this in the paper, of course, but I'll just say briefly, by way of summarizing the kind of case studies, that we have a very strong, unambiguous, as such ruling by the AB against the United States in US 1916 Act, where the appellate body stated that the 1916 Act was a fourth remedy, and it is inconsistent with the anti-dumping agreement. And because they struck down the US practice as such, not just as applied, the costs of compliance here were considerable, they were high, and the US failed to comply with the ruling. And then we see something interesting when this issue comes up again in Offset Act. So Offset Act crucially draws heavily upon the US and the complainants draw heavily upon the 1916 Act decision, so lots of precedent being cited here. And the AB has a choice to make, again, is it going to stick to its guns from the previous ruling, or is it going to adapt precedent? And what it actually does, in some sense, is it extends its prior ruling by saying, we told the US that it was guilty of using a fourth remedy in the past. We struck that practice down as such, and the US is doing it again here in the context of the Offset Act. And in fact, what we're going to do as the AB is we're going to extend our ruling about how the Anti-Dumping Act says that these civil proceedings are WTO illegal. We're also going to apply that logic to subsidies. So the Offset Act was ruled to be an illegal subsidy, and therefore it was an extension, in our view, of the prior ruling. This also then leads to clear compliance delays and non-compliance by the United States. So those two examples kind of illustrate what we have in mind. And then we see something interesting in U.S. shrimp Thailand, where we see a shift by the AB from an as such ruling to an as applied ruling. So this case is about the enhanced bond requirement. And here the appellate body, rather than hammering that same legal nail again, says the enhanced bond requirement is in spirit not strictly WTO illegal, but it is applied inconsistently and unfairly by the United States. So it crucially strikes the US policy down as applied, but that's a lower compliance burden on the US. It's a as applied ruling. It's a narrowing of precedent rather than expansion or extension of it. And we see compliance, albeit with a little bit of kicking and screaming, but we see compliance with this decision. So we hope what we're showing through these case studies, just to wrap this up, is that compliance can be more likely when the AB picks its spots carefully, when it behaves strategically, when it adapts precedent in a way that reduces the compliance burden on the respondent state. And crucially, what that means is the respondent didn't necessarily win the case. They still lost on key issues, but it was a more politically palatable, manageable compliance burden. And so I hope what we're showing is that strategic behavior by adjudicators can affect state behavior, and that ICs, then international courts, face this delicate balancing act between sticking consistently to prior case law in an effort to enhance their authority on the one hand and legal coherence. Those incentives are there, but then also trying to induce compliance means having to adapt to changing conditions over time. So there's more we can say about that, but in the interest of time, I'll wrap up at 15 minutes there. And thank you so much for your attention. We're open to questions.
Thank you so much, Sergio and Jeff. And I turn over to Krzysztof for the comment. And then please don't forget, you can already put your questions in the Q&A if you wish. Krzysztof.
Great, thank you. Thanks to the organizers for organizing and to the KPP team for a great paper. So this, I guess, is from KP to KPP with all my love. Okay, I want to make three main points. The first one is about the relationship between the pitch, like the motivation, especially in the paper, but it also came up in the presentation, and the rest of the paper, the theory and especially what's being tested. Then the relation between the theory and the empirics. And then, in a way, what I find most interesting and what I'm really curious about the audience's reaction to is the normative implications here, right? So the paper is motivated by this mention that adaptation to changing conditions is necessary on the part of international tribunals, and in fact that it's not happening fast enough, and yet what so to kind of provide evidence for that, to make this concrete, the paper refers to changes in the environmental expectations and technology, right? And so the kind of adaptation seems to concern the rules themselves. Right? And so this is the kind of adaptation which would seem to be, to me at least, more the task of the member states, i.e. the legislative branch of IOs, rather than tribunals. And that kind of gets conflated a little bit in the paper. My own reading is that tribunals are pretty quick to adapt to actual changing circumstances. Right? They can do it from kind of one case to another. They often do. And so, for instance, think of how quickly ISDS arbitration tribunals seem to have adapted to shifts in public opinion over things like fair and equitable treatment clauses and the country's right to regulate, for instance. And so when you mention changing circumstances, the thing that these tribunals are kind of adapting to, it seems that what you have in mind is state interests and really the defendant's interest in the case at hand, right? So the theory is, and what you test, seems to be about how tribunals have to be cognizant of the weight of precedent given who is in the defendant's seat, which is not to say that tribunals sometimes don't adapt to circumstances, right? So there's lots of, through precedent, there's lots of historical cases of tribunals like the US Supreme Court either rendering past precedent obsolete by not invoking them or outright overturning them in the face of actual changed circumstances, right? So think of Plessy v. Ferguson gets overturned by Brown v. Board of Education. And so by contrast, I think in your setting, what you're looking at really is adjustments to past rulings that in retrospect appear as having been overly ambitious, given what they ask of the current defendant, given the compliance burden they ask of the current defendant. And so this is about tailoring, past rulings to current political interests rather than, again, evolving technology or changing moral sensibilities or something. And that's why, to me, the normative case for this, which you, I think, in the paper make kind of tacitly, is far less clear, right? So along those lines, you have a pretty striking view of the interests of international tribunals. The exact citation, for instance, is they want to serve state interests, particularly as members' preferences evolve over time. Really? I mean, is it enough that states want to serve state interests, right? Is that really the obligation or even the political savviness of tribunals, right? This might be kind of a semantic question, but the way I think of it usually is something along the lines of courts need to remain cognizant of state interests, but not serving them. But that kind of is the tacit implication here. So again, looking to normative implication, the question is, what's the right scope for adaptation to state interests on the part of tribunals? And the tacit normative stance, at least in my reading, is that this kind of adaptation through precedent is seen as a net positive, irrespective of circumstances. And yet, at some point, the willingness of member states to have their interests so carefully listened to by tribunals probably starts to clash with their need for reliable and consistent rulings, right? So states, after all, are the designers of these things. They're the designers of these courts. So along these lines, we refer to compliance as a gold standard of cooperation. But I think we always have to remind ourselves that it has to be part of a twin standard, right? Compliance, great, but with what? If rulings get watered down over time, compliance is less meaningful, right? There's this great classic paper by Downs, Rock, and Barsoum titled, "Is the good news about compliance good news about cooperation?" Right? And I think that's kind of the question that to me is being asked in a way here. So look at how much sun Oxford is getting. This is such a rare event. I'm never this blinded. So this all raises this pretty central question, right? If tribunals are seen on average to narrow the meaning of past precedent, given who's in the defendant seat, then why was that precedent so broadly pitched to begin with, right? Is there a myopia on the part of the court? Is there this inability to see ahead? Or, and I think this is kind of my personal prior here, are courts just awfully bad at guessing what is going to be more or less onerous for states to comply with? Right? And so this might especially be true of the appellate body as opposed to panels, right? Because remember, panels are, well, the panelists often are trade officials who are actually pretty politically savvy. The appellate body, by design, is much less so, right? They tend to be a little more jurists than panels. I've done some work with Joost Pauwelen on this, so I've been really interested in that difference. So is the appellate body here in a way kind of taking a trial and error approach and then correcting their mistakes, as it were, their overly ambitious stances subsequently, right? So because we do see courts rendering rulings, but then being careful to kind of carve it out of subsequent jurisprudence. But that's not what you're showing here, right? It's not that there's this far-seeing nature of the court that thinks this might be a problematic precedent down the road. No, it's this backwards-looking correction. All right, so in terms of the empirics, right, you find that adaptation leads to more compliance, which I think is highly plausible, right? By making something narrower and easier to comply with, you get more compliance. But it's important to show that indeed this works. And then we know from your past work that past low compliance leads to more adaptation today, which I think is quite striking, right? So there's this kind of corrective. Again, it suggests a kind of trial and error approach. You have initially demanding rulings, which then get narrowed further down the jurisprudential tree in the face of non-compliance. Here's one thing that I think is worth keeping in mind. Adaptation, obviously, is pro-respondent, is pro-defendant. And so I would love to see more on these distributional effects, right? So for every defendant made happy by a narrowed ruling, there's going to be a complainant made unhappy by more constrained compliance. And so to me, the obvious follow-up question is whether this phenomenon yields to differences in power, right? So this is the worrisome bit to me. If the motivation for adaptation is the backlash by maybe especially powerful states, then we'd expect it to be unevenly applied. And so is that the case? How might we know? So in the cases that, in the very careful case studies that you outline, right, in terms of the complainants, the EU gets resolve on the part of the AB doesn't budge, it doesn't adapt, while Thailand gets a narrowed, adapted ruling, right? And maybe that's not a coincidence. And the question to me is, does that appear systematically? All right, here's another point of kind of a potential clash between what I think of the theory and the empirics. So the theory talks about this pretty gradual nature of adaptation, right? So this doesn't seem to be about compliance in the theory. This doesn't seem to be about compliance with the case at hand, but about shaping the past with a view to the future. And here, what we have is a risk of, I think, functionalism. So by seeing what you describe as a beneficial outcome, you conclude that this outcome is the reason why the action was undertaken. What I think is happening instead is that adjudicators are indeed focused on the case at hand, and that as an unintended byproduct of that, of the accumulation of all these adaptations, you have this gradual process that you identify in the theory. Right, so it comes down to what adjudicators think they're doing, and I'd wage that the systemic result is not actually their intent. All right, so this gets me to my very last point here, which is about the normative implication. The question to me is this kind of tailoring of rulings the role of tribunals, or should it be the role of members who are clarifying the rules? In other words, is this what you get when members can't agree? Isn't it up to other member states as complainants or as potential complainants to make calls over restraint, right? So in the case of the EU and the 1916 Act, the EU goes to bat, it asks for retaliation, it goes all the way. Well, isn't the EU in the best position to judge whether this is a wise move given systemic implications? Great paper. And I think one, again, that raises some pretty weighty questions, especially given where we are in the evolution of the institution of the WTO. And I really look forward to the audience's comments. Thanks so much.
Fantastic. Thank you, Krzysztof. I don't have questions yet in the chat. So if I may, some of the questions Krzysztof raised, I had as well. But I think I want to ask you one issue on where you say, especially in the case study part, right? So the precedent on when they strike down a law, the law as such in the anti-dumping cases, or as applied, narrowing the precedent. But to me, if I try to translate it, and I'm, because the question you raise is broader, it doesn't WTO is your case study. So I think about, for example, the European Court of Human Rights or the Inter-American Court of Human Rights, where you do have cases where they would find a violation via an administrative act or a practice. And then you have cases where they strike down, but they don't strike down, but they basically say your law is not okay. Now, once you have a law implicated, you have a parliament being involved. And that brings me to the question where I think you could frame your paper in that respect to Dan Roderick's trilemma, globalization trilemma. So I think that I mean, he did it more for trade. That's all good. But I think, you know, this trilemma between democracy, sovereignty, and globalization, where you have the international courts to whom you give the competences, is more. So I wonder whether in your database you have looked at more generally on the compliance rates, whether what was involved was a practice or, you know, as you say, as applied, or whether it was a legislative act which needed to be changed, because that might make a big difference. And you could compare that to the compliance rate at other international courts where, again, you have this sort of distinction, because complying with a, you know, if an administrative act or a practice violated the international law, you more easily comply than if you need to change the law. So I think that would be a question to me.
And if I could just reply to that briefly, you're absolutely right. That's a great question, and your instincts are borne out in the data. So one really nice thing about Lauren's data set is she coded precisely this distinction. So is this an administrative measure or a legislative action? And as we would anticipate, then the costs of compliance vary based on which one of those is implicated, and we find that compliance rates just in general are much higher if it's administrative rather than legislative. So you're absolutely right about that.
Okay, thank you. Now the questions are popping in, and I think you are also anxious, you know, to respond to Krzysztof, but I give you 5 minutes at the end, or more time if we have time. But I think you, for you, it's also most important to get the questions in, right? So so I have one participant who asks, do all adaptations benefit respondents? Maybe you can answer that quickly. If not, you know, keep it to the end.
They don't.
They don't.
They don't.
Okay.
They are quite varied in the way they distribute, and it depends what type of adaptations, right? Because we can have like narrowing, and then we have distinguishing. Narrowing tend to be more pro-respondent. Distinguishing, I think, is more pro-complainant, right? So in a way that they don't have like that bias. But I do think that the point made by Krzysztof before is actually not incorrect. But I want to respond that to his pro-respondent aspect of the coding.
Thank you. So let me turn to a question of Ezgi Yildiz. So Ezgi asks, first of all, she says, great paper. And I think we all agree on that. She really enjoyed reading it and she learned a lot from it. So she has a few questions about the empirical part. First, are there significant variations under different categories, themes you have, such as anti-dumping or agriculture, etc., when it comes to their stakes? She says, I very much like the high stakes cases distinction you have in your case studies. Is there a way to incorporate this distinction for your large N analysis? She has more questions, but if you want to quickly go on.
Yeah, let's talk about that for a moment, because I think that's interesting and it's important. So bigger picture, the thing that's really fascinating about looking at the WTO and looking at compliance, at least as we measure it, is that we might just instinctively feel that compliance declines in how high stakes a dispute is. And what we probably have in mind when we say that is something like how much trade is being disputed by volume. And it turns out that when you look at volumes of disputed trade, it is a really, really poor predictor of compliance, which is interesting for us, and it motivates some of this work because it implies there's something else going on. I mean, we already know that that's true, right? We've got somebody like Christina Davis's work showing that some of these disputes are kind of political theater, that there's a lot of variation in what kinds of trade policies get disputed anyway. We could go on and on about all the noise kind of in this process, but it is fascinating when we think about stakes that disputed trade volumes are not the most important part of the story here, it looks like the data suggests. And we took that to mean, well, then it must also at least be in part that compliance is determined by what the court is doing, and in this case, the AB. So stakes, we can also think about that more broadly. We could think about something like how many employees are affected domestically by a particular trade protection. We can think about how well organized those employees might be through a labor union. We can think about stakes in lots and lots of different ways. Some of those things are substantively important, but hard to measure. But so the short answer, just to end on that, is, yeah, the stakes matter, but the trade stakes themselves, which I think is what people typically have in mind, are actually, it seems, not the most important part of this.
Great, thanks, Jeff. Then the second question is, do judges and AB panelists' identity matter when it comes to narrowing, expanding, following precedent? Is there a way to include that in your analysis, even as a control?
Oh, that's a very good question. So, in fact, the early versions of my analysis, right, before Jeff and I worked together more on refining the data, was trying to look at some sociological aspects of the application of precedent, whether civil law and common law, they were more willing to do some. To be honest, at some point I got overwhelmed by the question, but because I couldn't find any predictor, right? So the easy answer is no, but maybe looking more closely, then you can find some. We use some of the characteristics that I think Jost had applied in a prior paper. I mean, the origin, the country of origin, where they have studied and what have you, right? Like there were like 10 different, and then there was with one exception perhaps, that maybe the older, the appellate body member there was a more willingness to depart from precedent, but it was not too strong, right? So that was the only thing, like white hair effect, I call it at the time.
Okay, third question. What are some alternative explanations to the compelling story you are telling? What are other factors can explain AB's decisions to adapt their rulings? Ooh, we have so many more questions. Anyway.
I'll just do one breath on that, if I may, because there's a really big picture one, and it's super hard to deal with, which is that adaptation might simply be an artifact of there being different facts at hand. And that's really hard to address as a research design challenge. So we've read these decisions carefully, and we tried to find cases that we thought were closely related to one another under these kind of family tree structures we have in mind. But we have a hard time ruling out the simple possibility that it's just a different case and some of the facts are different, and so the ruling doesn't look like the previous one. And that's a very real possibility.
Great, thanks, Jeff. And also thanks to both of you of being really up to the point and short with your answers. I have a question from Tommaso Suave. To what extent is your case study analysis unique to the US, given its current position vis-a-vis the appellate body? Could you please elaborate a bit more on your robustness check of this point?
Yeah, so there's a couple of things about the WTO that make it interesting from a research design point of view. On one hand, it looks like there are a lot of disputes. On the other hand, we'd love there to be a lot more, just so that our N was larger. So what ends up happening is that we know the most frequent participants are, of course, the US and the EU, but the US is in first place by a pretty significant distance. We chose the US not because we think it's exceptional for any substantive reason. We do have lots of quotes from other members, especially from dispute settlement body meetings, talking about precedent, talking about their concerns over precedent, talking about whether they think there's legal overreach or not. So we know other countries are talking about this, and we know other countries aren't always happy. We focused on the US and anti-dumping in part because it seems like an awfully tough case. There are a ton of anti-dumping disputes, as we said in the presentation, against the United States. That in and of itself is kind of prima facie evidence that the US is stubborn in this policy area. And so seeing variation in America's compliance rates, we think is meaningful to look at, because if anyone doesn't want to comply, it's probably the US when it comes to anti-dumping. So that's why we focused on them, but we are sensitive to the possibility that, you know, the United States is overrepresented in our sample, so to speak, both in terms of the case studies and, of course, statistically in the large N analysis.
Great, thank you. And maybe also as a follow-up question, question from Mark. Pollack, can you say something about how much it matters in the large N study whether the US is, in particular, is a respondent?
Yeah, so definitely, I mean, the US is a huge portion of our sample. Our results do hold, but they are substantively weaker when you sample restrict on eliminating the US as a respondent. What we didn't look at, and Mark, your question just made me realize that this could be interesting, is we looked at things like whether there are kind of great powers in the dispute, whether it's the US, the EU, but we didn't look very closely at who the complainant was more specifically. So Krzysztof raised the idea of power politics in this process in his comments. And presumably, if power really matters, it's not just that it can enable a respondent to be more stubborn, it's also that the complainant might bring heavier weight to their argument. Why? Because of things like the threat of retaliation down the road. So we haven't looked at that in great detail. No, that's a great idea. Thank you.
Great, thanks. Then I do have a comment from Lauren, so your co-author. So first of all, she thanks Krzysztof for his fantastic comments. And the reference. And the reference, I think everybody can see it. Krzysztof has put in the chat, in the Q&A. So can everybody see it? I guess, right? Otherwise, please put it in the Q&A. And then she also hinted that her book specifically unpacks the legislative versus administrative distinction more so than in the ISQ paper. And just for everybody to notice, it's delivering on promises, the domestic politics of compliance in international courts, University of Chicago Press, 2022. Then I do have another question by Mark. He asks, although your presentation focused on the case studies, there's really interesting large N analysis in the paper, and I wonder if you can give the audience a sense of that larger data, and also following up on Tommaso's question. No, that's something. No, well, right. No, okay. A lot, you know, on if there's anything else you want to share with us about this fantastic data set, which I think will be used by many people.
Of course, we would like to do that, and then I would like to address a couple of questions, good points made by Krzysztof, specifically the role of tribunals and how to think about the normative implications as well. So maybe
Sergio,
go ahead.
Let me just say on the large N analysis, and thank you, Mark, for giving us the opportunity to talk about that some more. This actually is an example of where we would love there, unfortunately, to be more disputes for us to include in our data set. So we're limited in our sample size or number of observations to just over 100 disputes where we have really good data on precedent applications by the appellate body. What that means is that we're pretty confident that the statistical correlation we find is substantively meaningful. But it does, we like to be transparent about this, it does limit some of the more sophisticated things we would like to be able to do in terms of testing for selection bias, which kinds of cases make it to the AB stage, which kinds of cases are ruled on particular ways. We just don't have a sample size that's large enough, frankly, to address some of the concerns that you might naturally have about whether our correlation implies any sort of causation. And so that's why we lead with the big kind of statistical correlation and say, look, there's something clearly here. Let's turn to the case studies and see if we can trace the lineage of some of these decisions over time. So the large N analysis is there, but we do like to be upfront about the fact that it's merely suggestive, excuse me, for a couple of different reasons.
I think, Jeff, did you finish your sentence or you just froze? Yeah, you finished. Sorry. Yeah, I didn't know if it was. Yeah, I agree. I think this is a problem with, you know, the way in which the cases work, right? The family of cases, right, became shorter and shorter. So it's very difficult to keep an analysis of that large N that is more robust. But just want to go back with the points made by Krzysztof about the role of tribunals, and I do think that you're right. Maybe the sentence there needs to be rewritten as it is, just to understand what is the role of tribunals. But I do think there is some sort of like a conceptual difference, right? Not all tribunals are the same, right? I do think that if you think of, you know, a commercial arbitration tribunal, right, which is not properly an international court, but could be hearing cases that are very similar to an ISDS case, right? Just the instrumentality of the state is acting as a private party. Maybe there is kind of much more an expectation of the individual in looking at that specific case, right? So as you move into a more institutionalized setting, right? Let's just think like the ISDS as the next level. Then you can think of ISDS under a more institutional setting, like perhaps the NAFTA or the USMCA that enables third-party participation by the other state, or what have you, right? Like there is like some provisions to incorporate the views of the state. And then you have perhaps, you know, the other end, you know, a setting where states are much more controlling of the setting. So in that case, I do think that the adjudicators have to be more conscious about the states as participant, but also founders, creators. And then I think here there is also one aspect that becomes much more theoretical almost, right? If you're really positivistic about this question, is that they know it has created a new legal order, right? That has to be independent from the states, right? And I think like then, you know, it's almost like what do you think is going to happen, right? I mean, what are the political consequences? Well, I don't care. I'm just reading the law, right? You can take that view, but I do think that, and this is my experience, that adjudicators tend to consider those consequences, right? And I do think that it's almost the worst outcomes are when they don't, right? When they just, and this reminds me, you know, one very famous case where you have like that annulment case in ISDS involving Argentina, where basically the annulment committee says like, yeah, you know, the tribunal is wrong, but this doesn't reach, it's really wrong, right? It's a, you know, again. And then, but then the state still loses, right? So how that state is going to be able to sell this to their constituencies? It's like, oh, we won, but we lost, right? So we won the case. They told us that we were right, that it was a very bad decision, that it was but we still have to pay $300 million, right? So I think that those aspects, I think, you know, are part of the considerations or should be part of the considerations of tribunal, maybe. But I do think that it happens as a fact. the tribunals, they know that, you know, at the end, the only thing that they have is the power of their legitimacy, and not like any way really to enforce these judgments.
And Sergio, if I could just follow up on that with just a few moments. I mean, Krzysztof, your comment that you know, the worry here is that the AB might be kind of bowing to the interests of stubborn or more powerful respondents, and then kind of, you know, you sort of phrase that, like, where does that leave us? That's exactly our core concern. I mean, we've reflected a little bit on what the normative or even just concrete policy implication of this finding is. But at least from a social science point of view, I think, I mean, this is the question in international law, right? You can be a court, and I know you don't like me calling the WTO's dispute mechanism a court, but you can be a court and say, look, we've ruled on this before. You didn't listen to us. We're going to say it again, and you can just stick to your guns on this, right? Or you can try to evolve. And maybe that smacks a little bit of bowing to the interests of the powerful respondent and letting them win something for having been stubborn. But this is the kind of the reality of the trade-off I think these adjudicators are facing. So your worries about the implications here are correct. And that's exactly kind of why we like this work, which is it's trying to grapple with, to the extent possible empirically, with this very real, very difficult trade-off, right? So you can be in a Downs Rock and Barsoom world where if you've bowed enough to the interests of powerful respondents, you're not left with much of an institution. But on the other hand, you can not bow at all and not be left with much of an institution if nobody's complying with what you do or say, right? So this is the balance of IOs, I think, broadly understood across essentially every policy domain. The lawyers among you may disagree with me, but I think that's kind of what you're worried about is exactly what we're trying to grapple with here.
Thanks so much. Sergio and Jeff, a question, because I have still a question in the Q&A. And so would you like to respond more to Krzysztof, or are you willing to take the question very quickly?
We'll take the other question.
Okay, so that's a question from Pedro Villarreal, who asks, when looking at individual WTO anti-dumping cases as part of the data, how did you frame disagreements between states and between commentators on how to understand the external context that justifies or not extending a precedent? Did you take a stance on who was right?
Yeah, that's part of the coding process. The coding process was exhaustive in many ways, and there were some applications of precedent where there was some concern, right? Some real disagreement, right? There was like very few of them where we wouldn't tell exactly if there was like an application, what type of application. But I would say that, you know, those were very exceptional circumstances, and in those cases we will try to convene a panel of experts to discuss that, right? A panel of experts that, you know, we had in the coding process, involving some of my colleagues in Arizona, and then determine, right, whether there was what side was correct. But I would say that that's part of the coding process, and I'm happy to talk more on a separate. But it's a very technical question.
Great. So thank you, and for all those who came in, thank you for your questions. And you see still on the slides the email. So if you have further questions, I think Sergio, Jeff, and Lauren are happy to take your questions. So that leaves it to me to really thank you so much for a fantastic paper, presentation, and comment to Sergio, Jeff, and Krzysztof. And I think that was a great start for our speaker series. And let me draw the attention to the next dates. On the 7th of February, we have Shiri Krebs from Deakin University and chair of the Liebe Society. The Technological Revolution in International Humanitarian Law, a Cognitive Behavioral Critique, which will be discussed by Frédéric Maigret from McGill, and Moshe Hirsch will be moderating. Then we have Taylor St. John from the University of Oslo, Bargaining in the Shadow of Awards, which is interesting because it's a topic which is close. Sergio is also one of the co-authors, but it will be Taylor presenting. There are many co-authors, so I don't name them all. On the 20th of March, this will be on Zoom because ASIL will not be organizing this one. Rachel Brewster and David Bigger will be discussant, and Mark Pollack will be moderating. And then we have, last but not least, for this spring term, Eric Furton from Georgetown, the effect of ideology on court rulings, the role of judges in state aid litigation before the Court of Justice of the EU, which is a joint paper with Silja Hermansen. Vanya de Burka will be discussant, and it would be moderated by Susanna Gocimierska. You can register again at the for those events on the ASIL website, except the one for Taylor St. John. I think it should be on the IG's website and how you can do that. And of course, we hope to see many of you there, and I wish you now a lovely rest day wherever you are, and how long it will be. Here it's a bit shorter. So thanks for joining and participating, and a very special thanks again to our speakers, and have a great